Welcome to the Data Stream, the podcast that dives deep into the fast-moving currents of data, technology, and the law. BakerHostetler's Digital Assets and Data Management Practice Group, DADM, brings you this series, hosted by partners David Sherman and Nichole Sterling, to explore how companies navigate the complex and often intertwined lifecycle of data, from privacy and cybersecurity to advertising, AI, and other emerging technologies. I'm Charlie May, and you are listening to Baker Hosts. On today's episode, David and Nichole speak with partner Matt Van Hise of our Digital Risk Advisory and Cybersecurity team. Matt was formerly Chief Privacy Officer and Chief of the Privacy and Data Security Unit at the Illinois Attorney General's Office, and a longtime leader in multistate AG privacy and cybersecurity investigations.
Hi, Matt. It is very nice for you to join us today. So one of we'll say probably the most interesting thing about your background before you joined Baker, and of course your time since you joined Baker has clearly been the most interesting part of your career, but you spent years in the Illinois Attorney General's office. What did your day-to-day look like? And also, here's what we really want to know. Is it that regulators just sort of sit around thinking of ways to penalize companies, or are there other things you're really doing every day?
Sure. Absolutely. Great questions. And thank you very much for having me. So that's correct. I spent almost 14 and a half years, almost 15 years at the Illinois Attorney General's office. And my day-to-day there was typically 14 hours each day, filled managing sort of three separate workflows. So I was the chief of the Privacy and Data Security Unit. I had an internal team of assistant AGs that were dedicated to privacy and data security investigations. I was also the agency's chief privacy officer and cybersecurity counsel. And in that role, I provided legal guidance, to the agency. And we had approximately 1,000 legal staff, of which about 450 were attorneys. And they covered roughly 40 different areas of the law. And then lastly, I led the National AG Privacy Working Group. And in that role, I was coordinating with all of the AG offices from the 50 states, the District of Columbia, and the U.S. territories. And I'll say, to give some background on what that part means. So when folks hear about AG offices bringing multi-state data breach or privacy investigations on a national level, that's this group. And it's safe to say, right? So day-to-day life there prepped me really well for coming into the firm already for any type of cybersecurity questions, issues, or crises that a client might be facing. So that was kind of my day-to-day. And you asked sort of the myth-busting question, are regulators really sitting around dreaming up ways to penalize companies? Despite what businesses may think, regulators are absolutely not sitting around dreaming up ways to penalize them. The volume of content coming into AG offices specific to cybersecurity and privacy is tremendous. There's so many incoming channels, whether it's the reporting of data breaches, direct consumer interactions regarding breach notices or identity theft, and then there's media reports on cyber-related issues. So there's a lot of inflow that's constantly occurring.
So really, you're just getting a lot of intel, so you're picking and choosing what's interesting to potentially look into.
Yeah, picking and choosing based on large number of individual affected, so large number of consumers for your state that are affected, depending on the types of data that may be affected. If it's a data breach, what may be something that's more sensitive than another area, or it may be a topic that's a priority for your attorney general specifically. And AGs are all individually elected individuals. They're sovereign in the sense that they all can do essentially what they want for their state. So different AGs have different priorities.
So Matt, what first got you into privacy and data security in the AG's office? And was there an investigation that really changed how you think about companies and consumers and the role of government or the role of the AG's office today?
Sure. So I was brought into the AG's office to more or less focus on being sort of the attorney who not only knew the law, but also who had a strong knowledge of technology and the internet. And the Illinois AG at the time, Lisa Madigan, was at the very top, really, of the AGs across the country who were focused on consumer protection efforts for consumers. And one of the consumer protection areas that she wanted to just absolutely dominate in was privacy and data security. And that was everything from identity theft assistance and prevention to being an early establisher of a breach notification law, to having a law requiring that companies enact reasonable security measures when handling personal information. And she made it very clear, not only did Illinois need to be a leader in this area, but we also needed to be a leader in coordinating with the other AG offices. So especially in leading the multi-state investigation. So, I'm fortunate, right? Because I got to come in aiding with the creation of what has become arguably one of the most prominent legal topic areas for regulators, for industry, for our clients, and for law firms. To your question, as to one investigation that made me think about companies, consumers, and the role of government today. So I won't single out any specific investigations because I've worked with so many folks over the years, but I'll say that I think that all parties have a role to play. I see companies and the goods and services they provide as, really the lifeblood of the economy. So I've always been a big believer that companies should be given a lot of space to innovate and develop their products and technologies. I see consumers and their data as really the digital currency that's driving the companies forward, and then the government. So I see the government really, in my opinion, as the checks and balances to this relationship. When it comes to regulating the privacy and data security space, the regulators really exist to ensure that this business relationship that's happening, to make sure that it remains fair and transparent and honest and protected and really importantly, balanced.
That makes a ton of sense. It's actually inspiring knowing, again, gaining those insights into the regulatory mind or a regulatory process or motivation. I want to follow up on one thing you mentioned, or two things really that you mentioned, which really stood out. So you said when you joined the Illinois AG's office, that was what, 16 years ago at this point? It's incredible that the Attorney General was focused on cyber risk or on privacy risk for that matter as well. That was well before I was in the space too. So, I don't think our field really existed at that time, or it was just emerging. What do you think drove that early emphasis and what brought you in and caught your attention?
Yep. So absolutely. So you're exactly right. That was right when the space was really starting to emerge. And what really, I think, drove this, at least, and I can only speak for Illinois, but identity theft was becoming something that was a new and emerging consumer protection issue in many of the offices, state AG offices nationwide. And many of them were really looking to tackle that right square on. And the Illinois AG's office was the first ever in the nation to create an identity theft unit and an identity theft hotline where they had dedicated staff members called consumer and identity theft advocates available to assist individuals who would contact in and say, I'm experiencing this situation. I'm not sure what's going on. I need assistance, or I need some guides how to safeguard my credit report or my financial information, or I believe my financial information has been exploited and I'm having issues maybe with my bank. So that's sort of, at least at the Illinois AG's office, sort of how that transitioned into what it was. It was really exploding. And for many, many years, identity theft complaints coming into the AG's office were among the top consumer protection related issue that was tracked on a yearly basis.
Fascinating. Second follow-up on that, and I promise we'll get back to regularly scheduled programming in a minute. But you were also talking a bit about the regulatory mission, enforcing fairness, making sure the playing field is essentially level for all market participants. And I'm paraphrasing there, sorry. But is there anything in your time thus far in the private sector that that would cause you to revisit any core assumptions or beliefs that you had as a regulator?
So my journey at the AG's office was unique in the sense that I wasn't always also the chief privacy officer. I didn't become the chief privacy officer until later on in the career. It happened here, actually, it was during the pandemic time that role was added in. And I would say my answer to your question would be different had I not had that role. But that role really helped me appreciate the struggles and the day-to-day issues and items that someone who is assisting managing a large organization with privacy and cybersecurity needs goes through. And that ranges right from everything, big all the way down to the small issues. And that's something that I really grew to appreciate from having firsthand experience on it. And had I not had that experience, that probably would have been an item that was a little bit more eye-opening for me, right? As we assist with our clients, because our clients, they have large organizations, they have a lot of complicated situations that they're faced with, and not everything is easy as flipping a switch and turning on a change or a modification to a privacy program or rolling out some new type of cybersecurity suite product throughout an organization. There's a lot that has to go into that and a lot that has to occur even in the planning stage before you can get to a final outcome. So that, I think, is a big component. I, of course, have direct access to right now, being a partner in our digital assets group. It's something that I appreciated immediately as I had that cybersecurity counsel role at the AG's office. So that's probably one of the biggest transitional type changes, I think.
Thinking back to, again, the several hats you wore at the AG's office, I know that, as you mentioned, one of your core roles was coordinating across multiple attorneys general or AG offices for years. What did you learn about aligning different priorities and perspectives, and how did that show up in how you facilitate agreement or that alignment process amongst client teams now?
Yep, so this is a great question. I could talk a long time about this, but I'll say, so I learned several things. First, that aligning different priorities and perspectives is never a downside. And second, rarely, if ever, is there ever going to be a task where only one way gets the job done. So my work with the multiple AG offices translates perfectly now to how I build alignment among the client teams that I have here. And it shows up everywhere. So it shows up in the communication process that I have with the team. We discuss, the goals up front, clarify roles and duties that everyone has. There's the promotion of open communication, which is absolutely essential and necessary. We articulate the changes that may occur throughout the process. And really, most importantly, establish that everyone should be patient with one another. Everyone has different levels of knowledge into various areas. And it's important that while things may be tense, depending on the situation that the client is encountering, and then we're working with them to help work that matter out and work through that issue, everyone has to be patient with one another. And that's sort of combining all of that, I think you get the most success.
So here's what I really want to know about all these AG offices. How much are they actually talking to each other behind the scenes? Like, we often, from the outside perspective, assume that everybody is sort of talking about everything internally. Is that accurate?
Yeah. So, and I'll say that is a great question as well. So the short one-word answer would be extensively. There's a minimum of at least 2 to 4 monthly privacy and data security nationwide AG working group calls occurring. And again, that's every month. On these calls, state regulators are coordinating on overlapping topics, initiatives, investigation opportunities. And mind you, that doesn't even include the calls that are happening multiple times a week with multiple AGs involved in this area that are tied to active multi-state investigations that they're conducting.
So it's not necessarily an accident when, the same company, for instance, gets a letter from 3 different regulators and is like, what a coincidence.
I would say more so that is definitely not accidental.
So thinking about those non-accidental reviews of specific things that come up, when you are wearing your regulatory hat and looking at a company's privacy or cybersecurity program, what would signal to you that this organization is serious beyond, we have certifications, we have framework alignments, you name it. What really stood out to you in a positive or meaningful way?
Sure. So I'll break it into 2 areas. So smaller organizations and then mid to larger organizations. So if it's tied to a smaller organization, and again, this is just, my opinion here, any program that's tied to an MSP, so a managed service provider, and that also clearly defines the MSP's roles, their responsibilities, their duties, obligations, and has policies and procedures that link up to it, that there is, for a smaller organization, that's serious stuff. That indicates serious business. If it's a mid to larger organization, then again, for me, my opinion, any program that is comprehensive, that creates specific leadership roles, that has teams, and then also assesses itself throughout the year, then that's really some serious stuff. And, bonus points if that entity also utilizes cybersecurity vendors effectively as well. That to me indicates serious business above and beyond the usual just frameworks or certifications that an organization may have.
Understood. I want to be careful with one idea that you just raised, which is, again, reliance within reason on an MSP, right? A managed services provider. And obviously, when they're tied closely to organizational policies, prerogatives, you name it, without naming names, are all MSPs created equal in the eyes of a regulator?
Right. Absolutely not. Yes, it's a great clarification point. So not all MSPs are created. First off, I'll say you cannot contract around your obligation to safeguard data. You can't contract around your duties to protect that. So the MSPs are absolutely not all created equal. It's not a one-stop shop. There are some that are doing just a standout, phenomenal job. There are others that servicing my clients, I would not put in a list that I would recommend. So it's a very important, that you distinguish between the two. So I'm so glad you brought that up. And even when you have those MSPs in place, we check the box, we have the MSP, we're going to now just specifically let them do their thing. It's all about the oversight that goes into that. The MSP is really there as an assistance component. So if you're a small organization and you don't have all of the abilities and all of the financial resources to do all of the things that would be necessary to have a comprehensive information security program that is well staffed, well funded, well tested, well assessed, well audited, the MSP is there as a way to sort of bolster certain components of that process and of those areas. But make no mistake, someone has to always be at the helm overseeing that process and making sure that policies and procedures link up to that and govern that process for, if nothing else, accountability. But again, to ensure that the data is being safeguarded in the way that it's intended.
It sounds like, too, this idea that your privacy program or your cybersecurity program doesn't necessarily have to be perfect, but a regulator would be looking for an understanding of what's happening at all times, sort of active movement toward improving it, a sort of knowledge of your gaps and some sort of sense that you're attempting to do something. And it does sound like, from what you're saying, that companies that are less than perfect, as long as they are really doing a good job of sort of auditing and assessing what their practices are and understanding and trying to mature the programs, that can be a sign of seriousness as well.
Absolutely. And, you can quote me on that. Perfection is not the expectation. That is not the standard that any regulator should be holding an investigation target to. Just as you said, if an entity has knowledge on a variety of factors that I won't go into all the details of, but let's just say of their data and also of the ways that they're safeguarding it and their cybersecurity program and infrastructure, and they are contemplating and carrying out to the best of their ability, based on size, scope, and complexity of their operations and what they're collecting. That is something that, if well documented and can be discussed with a regulator, if that regulator comes knocking, is considered as good evidence to display and to show to that regulator that, this is what we're doing. We're not just saying, well, this is outside of our wheelhouse. We're not sure how to do this, or we lack the funding to do this. And they just throw their hands up in the air like, well, we'll just hope for the best. Having all of those things moving, knowing that it's never going to be perfect, is absolutely strong evidence that you're making efforts to comply with the aspects of the law.
So on the flip side, and this is a question that probably a lot of people I think are generally interested in, is what are some of the red flags if you put your regulator hat on? What's going to tip you off that something really wasn't done correctly?
Sure. So I'll tell you the very top one and the easiest one to spot is an organization thinking that one person can cover everything cybersecurity for an organization. It's impossible First off, that's a horrible task to assign to just one person. It's overwhelming. It's a recipe for immediate burnout. But thinking that that one person would be all knowledgeable in matters of both data security and in privacy, and then also knowing how to ensure that the program is complying with the law. So the legal hat in there as well. It's an unwieldy expectation. And, I'll say sort of other items that are included with that. So if an organization, if a company is either lacking completely or having but not configuring their core cybersecurity safeguard, their softwares and their hardware, that is another big red flag that, raises concerns. Anyone can go and buy hardware and software and stick it somewhere. And even, they can even turn it on. But not having it configured, not taking the effort to know how it needs to be configured, that's an immediate eyebrow raise, an immediate red flag by any regulator that's sort of looking behind the scenes.
So I suppose the flip side of that question, right, when we think about all of these red flags is from a documentation perspective, what materials are just of the most significance, are gold when explaining a company's choices or decisions in the context of an incident to a regulatory authority?
Sure. So there's a few. And I will say, first off, the ability to provide information security policies and program information, the ability to provide privacy policies, and now probably more so important than ever because of what's going on in the landscape with comprehensive privacy laws, but privacy policies that also have historical dates of updates. That's something that's catching a lot of attention by regulators right now. Vulnerability assessments, remediation plans that are tied to those. Let's see, patch management logs are probably going to go down in the history of something that is always going to come up in some way if an attorney general's office or a group of attorney general's office is looking at a cybersecurity program. And it's something that seems to always find its way in any form of regulatory settlement that may occur. And then I would say another key item, probably cyber end-of-life plans. So those are gold. When you're thinking about systems, eventually they're always going to age out, regardless of whether it's a world-renowned operating system, or it's something that's providing microsegmentation, or if it's something that's on the journey to zero trust, some type of component that's built into that. There's always items, software components that are going to phase out end of life. And if you can show that you have an end of life plan and you can show that how that's going to work as you transition into something new, it's really going to be golden, right? Because often, and this is so unfortunate, but often situations will happen where a product is terming, it's coming up to its end of life phase, and the organization is getting ready to make a substantial change. They've made a huge investment in a new version of that, but they're in the process of rolling it out. What happens is sometimes vulnerabilities hit right in that phase, and sometimes they hit that product that's end of lifing. And being able to show that you had a plan for how to transition out of that really gives a lot of comfort that to a regulator, that it wasn't just a forgotten topic or ill-planned topic. It really gives a lot of credibility that, even if something unfortunate happens during that time, it shows that you were planning to make that transition. And it really holds a lot of weight for obvious reasons when you are working with a regulator or a group of regulators.
So without getting into specifics, as we think about presenting that information in a meaningful way, what works really well when companies engage with state attorneys general from a tone and transparency and cadence perspective so that the conversation stays productive whether or not they have any of those critical records or arguments to present?
So 2 items. The first one should seem just so absolutely obvious, and it is obvious, I hope, a lot, but believe it or not, from my perspective, having been on the other side doing this, you're surprised whenever it happens that it's actually occurring. And I'll say, not to build up suspense, so starting off from a non-adversarial position is literally number one. I can say historically from, again, my regulator days, I have engaged with countless law firms of all sizes. solo practitioners, general counsels, business leaders. And only a percent of those engagements resulted in inquiry. And only a percentage of those resulted in a subpoena or a civil investigative demand, a tool to get information from a target of an investigation. And then breaking it down further, only a percentage of those ever transitioned into an investigation involving a resolution. And what drove that process largely was non-adversarial. So communication tone, transparency of responses, responsiveness to deadlines. And, again, that's not to say that the perfect situation and the perfect relationships aren't going to evolve into some form of a formal request for information in the form of a subpoena. But I will tell you, the path to almost guaranteeing that process goes that route is if someone comes in and they're just combative throughout the entire process. They don't understand that they're subject to regulation, or they disagree, or they don't want to be regulated. They ignore requests. The tone and the affect in the communications are just very confrontational. That's really the first way. So to ensure probably that, like, the second item of importance, which is almost tied with number one of ensuring that the process stays very productive, is knowing your regulator prior to having to engage with them, or having your point of contact with the regulator be someone who knows them as well. So when I was at the AG's office leading these investigations for nearly 15 years, one of the most reassuring factors that would occur when I reached out to a business was if they responded with a point of contact that I knew. And, that makes sense. If you know someone, it makes the process easier. If I had worked with them, the reputation that they had built with me, because then immediately my guard would go down. I'd know what to expect. And, really what folks should look at is anytime you could put a regulator at ease from the moment of first engagement, it sets the tone for how the whole process will unfold going forward.
It's interesting that you mentioned that, having that point of contact. And I think one of the things we've tended to see somewhat develop between the concept of sort of U.S. regulators versus non-U.S. regulators is this sense that regulators outside the U.S. are somehow or another more collaborative, that people have, more ability to seek opinions from them, things like that. How do you recommend that people establish regulatory relationships in advance of, something like a data breach or something where they're having to report to a regulator about an issue that they're not particularly happy is going in front of that regulator?
So there's multiple ways. Without going into all of them, I'll just say, and I know this sounds wild, right? But there were many days where I would have a business call up and contact and say, hey, I saw you were here. I saw you were speaking there. I saw your office was doing this. I just want to let you know, or your office know, or your agency know, this is the space we're in. This is what we do. Sometimes they'd say, we'd love to come meet with you. We'd love to come and sit down and, just to do a little discussion and say, really, this is the opportunity for them to show that they're great stewards of the data that they have, and just have that cadence with that regulator. So that's one option that occurred a lot. Another option is, if a business doesn't want to engage that way, picking the right outside counsel, having outside counsel who knows intimately various regulators or all of the regulators, whether they have worked in those spots and then now have transitioned to private practice, or whether they have just engaged in that space a lot in conferences and in many other ways. Really choosing that and choosing the right individual to do that is core. So that happened a lot. And then, other ways would be, often you run into general counsels, chief information security officers, chief privacy officers, and the like at conferences, at events, whether they're speaking or maybe a regulator speaking. And then there's a little bit of, communication engagement. I promise you, those regulators remember those situations. They remember those opportunities. So if you have outside counsel that has those relationships, already you have an edge in. But if you're having an outside counselor, or if you're coming to events and you're taking the time to introduce yourself and say, either A, hey, I'm working with such and such client, just want to let you know, or if it's you yourself, hey, nice to meet you. I'm, doing this at this business, at this organization. little small 30-second to 5-minute conversations, communication pieces are worth more than folks think, because right there you've established that relationship that you can draw back upon should the need ever arise and a regulator comes knocking and says, hey, I have questions. Those are probably the best examples I can give.
So there we go. Networking tips from Matt today too. So what is a principle or a sort of rule of thumb, something you've taken away from your time in public service that you feel like you still rely on or use every week now that you're in private practice?
So rule of thumb from my time in public service. So probably best 2 words: be honest. Perfection is an illusion. No one is expecting it. Be transparent. So I myself, you, David, all of the exceptional attorneys that we have here at BakerHostetler, we all excel in how we service our clients. And part of being able to do that at the level that we do is because our clients communicate with us where their vulnerabilities are. We're not interested in judging. We are here to provide companies, individuals with the very best legal advice and services possible. But we can only do that if we have the full picture of what's going on, and that comes from honesty and transparency.
Good tip on that one as well. Networking and rules of thumb from Matt. So we'll move on to a couple of fun questions. We like to sort of work these in so we can get to learn about what people do in their spare time. I understand that you are a big extreme weather enthusiast, and you and I have had the conversation in the past that we are the rural farm kids on the team. So having grown up in the Midwest on farms. And so we know that the best evening activity as a farm kid is just sitting on the porch and watching storms roll in because you can see forever in the Midwest. So here's the question for you on extreme weather. If you could banish just one type, you have to pick one type of extreme weather that you could get rid of. Which one would you choose? And you're welcome to go into the climate change discussion if you really want to, but we're not going to make you. You can just choose a type of weather here.
That's an interesting question. You'd think that maybe I would say like earthquakes or volcanoes, but I'll tell you, if I had to pick one to banish, it would be flooding. So, like you said, I won't dive into the climate change topic. I don't want to give the audience, I don't want to make them sit through any of that, but I'll say flooding, because when it occurs, it's absolute widespread total devastation that comes with it. And it has such a drastic effect on communities, on individuals, on agricultural, that if one could be done away with, that is the one I would banish.
It's funny because I was at a New York office event last night, and I informally polled random people on that question, and they are all in alignment with you. It was either hurricanes because of the fact that they cause flooding, or sort of flooding generally.
I was just thinking about my own answer to that question. Sorry. Flooding's a good one. Flooding's a bad one. Flooding's terrible, which means we should do away with it. Not good. That said, we also saw, or at least understand, that you are an Eagle Scout, which is awesome. Here's the big question. What was your Eagle Scout project? And bonus points if it involved fire or axes or something that made your troop leaders extremely nervous, or parents.
So that is correct. I am an Eagle Scout, and a large majority of my scouting career, and still today, because I live in the Midwest, right, does involve axes and fires, because those are things that folks do and engage with as activities in their personal lives, whether it be camping.
It's entertainment in the Midwest.
That's right. So my project. So I partnered with a group in my hometown that provided single family assisted living arrangements to disabled adults. And I completely renovated the outside living quarters and landscaping of one of these homes so that the occupants could enjoy, outdoor living and backyard life, both in a way that was safe for them and also required low maintenance upkeep year to year.
That's very cool.
That's wonderful. And it may not have involved an axe, but it sounds like it did involve at least saws.
Power tools. There had to be power tools.
Power tools, maybe some welding.
Absolutely. Without a doubt. Yes.
So we have fire and axes. Good. I'm happy.
So thank you for your time today, Matt. Final question for you, and we ask everybody this on the podcast. So as we wrap up, what is the sort of one thing that you would tell each in-house counsel who might be listening to this podcast to be paying attention to right now?
I'd say now more than ever. And folks that have heard me talk on topics before will know that I've said this in prior situations because it kind of runs true consistently. But now more than ever, know your data, know what types of data your company is collecting, why you're collecting it, what you're doing with it, how it's stored, how you're securing it, and who has access to it. And I say that both from a data security perspective, should there be a data breach, but also from a privacy perspective. Again, for folks that are tracking it, there's 20 states already that have comprehensive privacy laws. So knowing your data and how it's being collected is more important now than it ever has been before. And the last thing I'll say is thank you again to both of you for allowing me to participate and join. These have been great questions, and I really enjoyed it.
Thank you so much for taking the time to talk us through some of the mysteries of the inner workings of the regulatory landscape.
Absolutely.
Thanks very much.
If you have any questions for David or Nichole, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.